that what you call ourselves, right? Very happy to see you here this morning. I know many of you are excited about becoming attorneys in the future. I've been an attorney for 15 years now. It's hard to believe, but I was once sitting in the exact same seat that you were. And I wanted to talk to you today about what it means to engage in lawyering during a time of crisis. Because I think that one thing that we can start with in terms of our understanding of the current moment is it is indeed a time of crisis. And I'm so thankful for Andrew and Phi Alpha Delta for bringing us here together today, because in these times, we do need to think about how we can use our tools and our talents as lawyers to be more than folks who are out to make a living, but more so to be folks who are out to make a change. At Howard University School of Law, where I am a professor, we have a saying that originated with one of our founders, Charles Hamilton Houston. That saying is, and listen closely to this one, a lawyer is either a social engineer or a parasite on society. A lawyer is either a social engineer or a parasite on society. Charles Hamilton Houston was Thurgood Marshall's professor at Howard. Of course, Thurgood Marshall was the first African-American Supreme Court justice, Mr. Civil Rights, and his litigation in Brown versus Board of Education led to the end of segregation in the United States. So that quote, I'm going to ask you some questions about that quote after this talk, if we have an opportunity. But that quote serves as a bridge into our discussion today, because you have to ask yourself, in a time of crisis where there are world conflicts and pandemics and political toxicity is on the rise, and there is economic uncertainty, social media controversies, and of course the Supreme Court on the brink. There's so much to be worried about. And so a lawyer could come in during this time as a parasite on society and take advantage of these opportunities for money making or for other types of self-interest. Or a lawyer could walk into this moment and say, how can I make a difference? How can I make a change? How can I solve these problems? Ultimately, an attorney is a problem solver. An attorney is a problem solver. Your client comes to you with a problem. That problem could be for a large organization, a tax problem. It could be a criminal problem if somebody is facing prosecution. It could be a civil problem if somebody is in the middle of a divorce and they're looking for a solution in terms of custody. I'm going to talk to you today about what to do if your client perhaps would be conceptualized as American society and you want to solve some of these core problems that society is facing. So for me, if you're looking at different strategies for lawyering in a time of crisis, if you intend to be a social engineer and not a parasite on society, you have to go through these four steps. I'm going to go through these steps as quickly as possible, and I'm happy to engage with you about them in more depth afterwards. And once again, I am a professor, so I came here to teach. So I'm glad to see some of you with your pen and pads out, because this is going to be a information heavy. I'm not going to quiz you afterwards. I know you guys have had enough of those quizzes, but I do want to talk to you about these concepts in more depth. So understanding your theory of change. What does it mean to have a theory of change? Many attorneys who are seeking to change society for the better, at some point in time will have to come to grips with the fact that there are different ways that lawyers can change the world. For some people, they believe that if you can provide access to justice for more people, if more people who are facing prosecution and who are, we use the term indigent, people who cannot afford representation. If more of those people had good lawyers, whether that included somebody facing a criminal charge, facing prosecution, or somebody in a civil case facing litigation in a civil trial, once again under a theory that might involve a custody battle or might involve what we call a tort, a personal injury lawsuit. Can we provide access to justice for those people? Can we provide a free lawyer? Do you believe that you might want to be that public interest lawyer, that public defender who represents people who are facing prosecution from the government? People who are poor, people who are in situations where they're completely overmatched. Do you want to be a public defender? Or do you want to work in legal aid, perhaps? And be someone who represents people who are not facing a criminal charge, but who are facing eviction. And without your help, will not have the resources to fight against a majorly powerful landlord who is looking to put them out on the street. Do you think access to justice is the way that you will be a social engineer? Law reform, do you believe that instead of focusing on individual cases on the front line, do you want to be someone who works in reforming systems on a political level? You may think about Thurgood Marshall's campaign as a law reform campaign seeking to change the system of segregation and reform that system so that we have a system that allows for all of us to sit here together in this ballroom today. Do you think that we should change policy when it comes to climate issues? Do you think we should change policy when it comes to healthcare issues? Do you think we should change policy in terms of tax issues? There are many different issues that are up for debate in the halls of Congress and in your state houses. And those are attorneys overall that are at the cutting edge of determining what's going to be in that legislation. So how does that work? How do you fight to reform laws as an attorney? It is attorneys, the attorney in the room is the one who is going to draft the legislation. So legislative drafting is a skill that attorneys are helpful with. It is attorneys often that are involved in legislative advocacy work, providing testimony in hearings across the country. It is attorneys who are working with Congress members or other legislators to help them determine what policies would be in the best interest of their constituency. So oftentimes, attorneys will be drafting reports and gathering data to inform lawmakers. So law reform, access to justice, what about rule of law? Do you think that we need to fight corruption and fighting corruption is the way that we're going to change the world? Do you think that we need to uphold institutions like the Department of Justice or even internationally upholding institutions like the World Bank and the IMF that can go around and look for holes that allow individuals to engage in financial expropriation of resources in the system? Moving forward, in the interest of time, I just want to talk a little bit about these last two, democratizing law, the idea that we're going to be better if more people participate. Do you want to be part of the group that is, for example, next Tuesday, we all know what's going to happen, right? We're going to go to the polls, but also are you going to be part of the group that helps provide access to the polls? Poll watchers, people who fight against voter suppression. And then this last one, movement lawyering, which is a term you probably have never heard in your life. This is my theory of change. This is the way I believe that we should work to try to create a better society. Going to move a little bit back here. So this theory that I've articulated with these four concepts, this is the movement lawyering theory of change. Movement lawyering theory of change. So what that means is, for me, when I set about trying to be a social engineer in American society, I follow these four steps, and we call this movement lawyering. So there are many different types of lawyers, There are civil lawyers, there are trial lawyers, there are appellate advocacy specialists, appellate attorneys, Supreme Court litigators. There are lawyers who work on mergers and acquisitions, contract lawyers. There are lawyers who have many different specialties. For a movement lawyer, the way I conceptualize my work, I'm a lawyer for particular social movements. Because under my theory of change, I believe that social movements change society, not lawyers by themselves. Society is changed by a broader movement, maybe the Black Lives Matter movement, maybe the movement for the 99%, the Occupy movement, maybe a movement for another sort of social change that you're a part of. Those movements are what, under my philosophy, those movements are what will allow us to change society. So my challenge then, as an attorney, is how do I use my legal toolkit to try to help movements? So as a lawyer, I have a certain set of tools. How can those tools help make change? For me, two initial steps that I engage in, I try to understand my theory of change, right? We've just done that. Number two, I engage with a particular theoretical framework so I understand the substance of my issue. If I want to focus on the climate justice movement, right? I need to understand a little bit about science. I need to understand a little bit about climate change if I'm going to be helpful in that movement. So you have to understand the theories that are core to the movement. And then these last two techniques are very important as you think about how you go about being a lawyer. Two big takeaways that you always want to have in front of mind as you begin your legal career. Number one, how are you going to treat your clients as an attorney? How are you going to treat your clients? How are you going to interact with your clients? And number two, how are you going to advocate for your client, doing more so an integrated approach to advocacy as opposed to a limited approach to advocacy. Some people look at attorneys as if the legal system is a Xerox machine. The attorney is like the IT guy, and you're just there sort of fiddling with the machine to try to make it work for your client, right? That's a very limited way of thinking about what it means to be an attorney. An integrated advocacy model allows you to think about how do you fight for your client? Fighting for your client in the courtroom, fighting for your client in the halls of Congress, fighting for your client in the court of public opinion, fighting for your client in the streets if your client is protesting. How do you fight for your client on many different possible battlefields? That's what it means to be an integrated advocate. And when you're working for a movement, that movement is what I call a mobilized client, a client involved in a campaign. So very quickly, and I know this is going to be one of the controversial aspects here, I'm a supporter of critical race theory. I was actually someone who studied critical race theory as a student. There are many places in the country where maybe this entire portion of the speech would be banned, I guess, but thankfully not in Virginia, as you can see here on the map. We're able to have this discussion. So my theoretical framework is critical race theory. And what it allows me to do is to think about fighting against racism from a perspective that includes an understanding of the Constitution and an understanding of American society that is not unsophisticated, but instead takes into consideration the actual context in which we are living. For example, we live in a society where unconscious bias is a reality. Harvard University has a website and a program called the IAT, the Implicit Association Test, IAT, you can Google that. Hundreds of millions of people have, from around the world have logged on to this IAT program, and they've taken a test which shows whether or not you have any sort of unconscious racial bias. They flash people's faces in front of you, and you have to click whether or not that face is intimidating or not in like 1 or 2 seconds. Studies have found that most people in American society have unconscious racial bias, including Black people themselves have unconscious biases against other Black people because of the way society instills in us racist concepts. It's almost like it's in the water. As a result of the reality of unconscious bias, there is a critique of this idea that we should be colorblind because your bias is unconscious. So even if you say you're colorblind, there's still an unconscious mechanisms working. Okay, so that's a societal study. As a critical race theorist who engages in colorblind constitutionalism, I would make the next logical leap to explore why do we have an interpretation of the 14th Amendment that aspires to a standard of colorblindness which science has told us is impossible. Why is our 14th Amendment constitutional standard forcing us to aspire to an impossibility? Instead of fighting for equity, we're fighting for a scientific impossibility. Very controversial concept, right? So, okay, but that's my core concept. So by understanding that core concept, I am now able to engage in advocating for my client in a way that includes my client's core principles, my client being, say, the Black Lives Matter movement. So by understanding concepts like intersectionality, by understanding concepts like colorblind constitutionalism and its flaws, I am then able to engage in legal advocacy. Once again, litigation strategies, legislative strategies, other types of strategies inside and outside the courtroom to try to create sustainable change. So if you would click on a couple of those first two links to state court. So this is just a sample of an amicus brief. You scroll down, and click to the brief, Sundiata Colli amicus brief, right there, yeah. Amicus brief we filed in the state court of New Jersey, advocating for the parole of someone who was wrongfully denied parole for over 20 years in New Jersey prison, and we were successful by helping to make the case that oftentimes those parole decisions are tinged with unconscious bias because those parole decisions allow those parole boards to use a great deal of discretion. And in that discretionary decision-making, we found through scientific studies and legal research that there is unconscious bias. So you see that connection? I was able to take some of the ideas from the theory, integrate those ideas into my amicus brief, and we ultimately had a successful outcome where this individual was released from prison. He had been in prison for over 40 years, wrongfully incarcerated. So here we are able to take some theory, some scholarship, and mobilize that into some litigation strategy. If we go back to the PowerPoint, move over to the bond hearings one under court watching. Another technique that we use is we will actually go to courts and attend court hearings. One thing I would recommend everybody here do who is able to attend court. You want to be attorneys? Attend court. Raise your hand if you've ever been in a courtroom before. Okay. That's right. I hope you weren't a defendant. I hope you were just observers. Attend court. Attend court. And in 2022, many courts, we're hoping more and more courts are going to be accessible virtually. There will be access to courts on Zoom. Looks like this is not working. Okay, right back to that. So what we did, and those things will come up very briefly, and you'll be able to see an example of this. We were able to attend court hearings in Prince George's County, Maryland, myself and my law students, and we were able to observe the bail hearings and the bond hearings. Now, many of you think about trials. I don't know if you guys are too young for Perry Mason. Has anyone here seen Perry Mason before? Okay, couple of The CAD executive saw Perry Mason. I don't think he see this. I'm not sure what lawyers you all are familiar with, but many people think about the courtroom in a way that is completely over-dramatized, in a way that is disassociated from real life. But in 2022, you can actually attend hearings and observe what's taking place. What we saw in our report here, if you scroll down, we were able, essentially, this is a description of our report, and what we saw were many instances in Prince George's County in which people were arrested and held on bond, who, when they had an opportunity for a hearing, were unfortunately denied an opportunity for a translator if they did not speak English. Some people, if the technology didn't work correctly, this was during the time of COVID, they did not have an opportunity to even hear what was taking place in their hearing correctly because there was such a bad connection. We had people who were treated poorly by the judges and were told to hurry up. They didn't want to hear their entire narrative. They were made to rush through their argument. This is a very interesting issue when you think about bail and bond hearings, because one of our partners, Civil Rights Corps, has made the argument that by demanding that people pay money for bail, cash bail systems, you are essentially creating debtor's prisons. So poor people who cannot afford to pay their bail end up staying in jail longer than people who can afford it. So there's one lady who was in jail for over a year simply because she could not afford to pay her $100 bond. This is in Prince George's County. Rich people who can afford to pay that and are able to access the bond system are able to come out the next day. Remember, this is pre-conviction. This is after arrest. You're arrested, you go to jail, and then you come before the judge and you pay your bond, or you find a bail bondsman and you are released if you are able to do so. For folks who don't have access to that system, they have to stay in jail. And especially during the time of COVID, so there's no social distancing in jail, right? Many of these people were exposed, right? All right, so we can go back to the PowerPoint. Just want to give you a taste, and then lastly, we'll go to the campaign support one. I just want to give you a taste of what we're doing. So in this project, we are working alongside an organization that is fighting against the school to prison pipeline. It's called the Black Swan Academy. This is a very interesting program here in the DC area, which involves young people who are teenagers themselves taking the lead as directly impacted people in seeking to change school disciplinary policies in the DC area. What we do as attorneys is help them to come up with their campaign strategy. Of course, these young people are not going to be initially prepared to draft sample legislation for the DC City Council. We help them draft that legislation. We help them prepare for testimony before the DC City Council. Young people here are advocating for changes in the way that the SROs and the school resource officers interact with them in the school systems, whether or not they should be armed. These are questions that young people get to have a voice on, and we help amplify their voice as attorneys. This is another way to address one of the core issues in my work, which is this idea of trying to fight mass incarceration, right? How does it happen in the school system, the school to prison pipeline? Is it something that we address through the bail system and the bond system? Is it something that we address on the back end through the parole system? Parole, cash bail, school to prison pipeline. So you see, we're addressing the same societal issue, but we're taking three different approaches as legal social engineers. And we can go back to the PowerPoint. So, great. So in this process, we're constantly working to engage with the clients in a way that is participatory and is engaging. You listen and reflect. You seek to learn and grow. You interact with your clients in a way in which there is mutual learning. It is not a situation where you're looking down on your client, you allow the client to participate and collaborate in the representation. Their voice is present. You offer resources to the client. You put in time for the representation. You do all your homework. You study your client before they even meet you. There is a concept in the law called zealously representing your client. Zealous representation. Representing your client with zeal is the standard. So what does it mean to represent your client with zeal? To actually care about people. The lawyer as the friend, the lawyer as the ally, the lawyer as the champion, right? You are entering a profession, and this also may be controversial, but I'm going to say it. You're entering a profession where there are people who are willing to put in the time, energy, effort, spirit, soul, emotion to help other people. You're entering a profession of really good people. So many times people say lawyers, liars, can you tell the difference? Lawyers are sleazy, lawyers are these hired guns. That does not have to be the way that you practice law. Lawyers can be heroes, lawyers can be champions, lawyers can be people who change someone's life and even help change entire societies. So I want to leave you with that. I know there's not a lot of time. It was about 30 minutes left for discussion, but I want to have a discussion that's engaging with you all. But in our practice at Howard Law School, and this is a little pitch, Howard University, wonderful law school, open to all applicants, one of the best law schools in the country for people who are seeking to make a difference in society. We're trying to build community. We try to engage with our clients and engage with our students in a way that helps to build them up, not to put them below us, right? We're not lawyer-centered, we are client-centered in the way that we train our attorneys, in the way that we train our law fellows, our professors are interested in making sure that everyone who leaves our building is an attorney for the public good. Every attorney, I believe, should be an attorney for the public good. Every attorney should be an attorney that is involved in making the world a better place. For you all, who are members of Phi Alpha Delta, you have a special responsibility because you have been able to build relationships with each other. Even before entering law school, you have a built-in support system, and you have access to resources that other people don't have. And more than anything else, I think you have the opportunity to inspire each other with the wonderful things that you're going to do over the course of your careers. So that's all for me. Thank you for your time. And
two microphones. One will be here with Liz, one is there with Andrew. So if anyone has any questions for Professor Hansford, please raise your hand and we'll bring the microphone to you.
I've got one right here.
Wonderful. All right, Liz.
Hi, my name is Braden. I'm from the University of Florida. I really appreciated your presentation. I just had a few questions. Specifically, we're living in a time of crisis. A lot's going on. We have a complete breakdown in the trust of our systems. What message, so talking about the trust of systems, the politicization of the Supreme Court. In Florida, we have a lot of issues right now, specifically with voting rights and former felons having to pay fines before they can even vote. So my question is, how do we trust these systems when they're failing right in front of us? How can we make change when we don't trust the systems in front of us? I know that's a hard question, but how can you make us in our generation, Gen Z, trust these systems that have existed for a long, long time when there are so many issues in front of us? Thank you so much.
It's an easy question to start off with. Well, again, you are in a special position as a future attorney. Attorneys are public citizens. So what does that mean? Attorneys are the ones who are the architects of our institutions in American society. Lawyers are leaders, not necessarily by accident. Lawyers are leaders because the tools that you learn in law school put you in a position of leadership, not just having the gift of gab or something like that, which is part of it, but more so understanding the structures of all of our institutions in American society. That includes corporations, that includes, of course, government. I think over half of our leaders in Congress are attorneys. In most state houses, you have attorneys who are representatives, and of course those who are not attorneys themselves, their offices are full of attorneys. Every major institution, even social media and sports and all of these major institutions, all are filled with lawyers who are advising people and ultimately, in many cases, making the decisions that the CEOs follow, that the elected officials follow. So for you all, again, this is a little different for you than the average citizen. You're a public citizen. So for you all, it's not just an option just to observe institutions, just say, oh, that institution isn't working too bad. You actually are part of the architecture of that institution. You'll have an opportunity to structure it. So for your generation of attorneys, I think that you have to change your perspective and not just necessarily enter your interaction with these institutions from a position of loss of faith, but from a position of what can I do here to make this institution work. So for me, being a social engineer, if you think about that term, a lawyer is either a social engineer or a parasite on society. An engineer, what does an engineer do? An engineer is designing structures and systems so that they can function over a long period of time, even after that engineer is long gone. What you engineered, that car or that mechanism you engineered, will continue to function or be duplicated. So as a social engineer, I expect, especially Phi Alpha Delta attorneys, I expect you to be engaged in the process of thinking, how can we create functional institutions in American society? How can we create functional democratic institutions? You may have come to the conclusion, which is probably accurate, that many of our institutions are flawed and are not prepared to meet the moment. Political institutions, economic institutions, social institutions. And so as a student, I challenge you to engage in a critical thinking project wherein you don't just learn enough to pass the bar, but you learn how to redesign these failing institutions. There's no blue book out there that's ready-made, or else we would have used it already. So what you're gonna have to do is ask the hard questions, look at the research, talk to your peers, talk to your professors, and be creative and come up with some possible solutions and practical solutions. As attorneys, we're practitioners, meaning that we are more so than the philosophy professors. We're practical people. So we need to be thinking about how we can change these institutions to make them work. And then that thinking can then help to influence campaigns, movements. Again, like I said, working with Black Swan Academy, right? We're partnering with campaigns, not trying to take over, but being willing to provide our resources, which include our thinking, to help think through how can we change the school disciplinary system so that it's no longer a school-to-prison pipeline. Instead of having a police officer in every inner-city school in Washington, D.C., maybe you should have a system of counselors and mental health practitioners and people who are willing to be violence interrupters and other systems that could be put in place so that when there's a problem, you don't just throw another kid into jail, but instead you actually help to provide healing, right? That's a solution that seeks to change a broken system like the school-to-prison pipeline. So democratic politics, small d, democratic politics is an issue in terms of participation, in terms of representation. Think about legislative gerrymandering. Think about, as we've described, the problem of felon disenfranchisement. These are the types of issues you get a chance to be an architect in terms of a social engineer or architect. You actually get a chance to come up with a solution as a lawyer. That's why it's exciting to be a lawyer. I'll be honest, I'm not necessarily a trial lawyer. I've talked about a few cases I've taken here and there, but I'm more so a professor and then a movement lawyer in the sense that I'm trying to change society. So for me, that's what's exciting, is the opportunity to change these broken systems. And I think as a lawyer, you get a chance to do that.
My name is Dom. I'm from Roger Williams University. And you spoke about critical race theory. My question to you would be, what are some of the misconceptions of critical race theory and how we kind of tackle those misconceptions through the work that you've done?
Great question, Don. Critical race theory is very poorly understood, which is not surprising because it's a very complicated theory that was born out of American law schools. And if you're not an attorney who understands constitutional law, for example, or the 14th Amendment, how is someone really going to explain to you why the way that we currently interpret the 14th Amendment is flawed on the grounds of unconscious bias, when it's much easier just to say that these critical race theorists are horrible Marxists, people who want to change everybody's gender or something like that, and that preach hate against other people. So that gap in understanding in part comes from the fact that whenever you take a complicated theory and try to use it for political gain, you're going to have an issue. So there's a group called the African American Policy Forum, which was founded by Kimberly Crenshaw, who is the scholar who created the idea of intersectionality. And they've been doing a great deal of public education. The last 2 summers, I participated in something called the Critical Race Theory Summer School. And we have courses that are online. You can go back and watch those to get a more thorough understanding of some of these concepts. And the concepts are very interesting and complex. They talk about how race is a social construct and how, when I went to Brazil, I lost my passport and I had to get a new ID. And when I told them my race is black, they laughed at me and said, "You're not black." And here in Brazil, we'll call you're something called Moreno. Moreno, I cannot pronounce it, obviously, or Pardo. And you're not black here in Brazil, And of course, I was shocked. I said, "I've been black all my life." But they said, "No, not here, you're not black." And so each society has a different conceptualization, perhaps, of what race means. So race is not something that is built in. So those sorts of concepts are core critical race theory concepts. Not easy to put into a soundbite, but the social construction of race, intersectionality, unconscious bias, those concepts can be learned if you check that website out. And I hope more people, in terms of fighting against misconception, I hope more people engage with the theory. Now, these theories are not uncontested. I do want to say that. There are people who disagree with these core critical race theory ideas, which is legitimate. I think I'm a person who believes in always listening to the strongest counter arguments in any situation and taking them seriously as a scholar. So there are people who disagree with core critical race theory concepts. So you should listen to both sides. But I do think that you should at least listen to the honest representation of both sides and not dishonest representations. Yeah. And why you're doing that? I got that from law school. Law school is what taught me to listen to both sides of an argument like a judge would in courtrooms before I make my conclusion, right? So people, some people go to law school to become practicing attorneys. The idea of being able to think like a lawyer is a life skill that I've used over and over again throughout my career. And that's one of the things I learned. So I will listen to the best arguments on both sides of issues before I make my conclusion because I want to be right. Okay, next question.
Hello.
Hello.
So nice to meet you. Your speech has been amazing so far. You're an amazing keynote speaker. I just want to to say.
Oh, thanks.
I've learned so much information, but my question here for you today is how do you start changing critical race theory in early education systems, starting with kindergarten, pre-kindergarten, starting early with the babies, the basics?
Right. Right. No, it's, again, it's, kindergarten is not going to understand 14th Amendment. 14th Amendment. I don't even know, how many law students understand it, right? But I think that we do have to be able to enter these schools and have an honest discussion of history. So the way the critical race theory discussion has played out in American society on the K through 12 level, that discussion has really been about American history and what elements of American history do we feel comfortable talking about and teaching, and what elements do we think people should not talk about because it would hurt people's feelings or make people feel uncomfortable. And so that's really the debate on the K through 12 level is, are we going to talk about those difficult moments and have an honest reckoning, or are we going to try to avoid those discussions for fear that those discussions are divisive, right? And I take a position that you can have difficult discussions and difficult conversations with people and not be divisive about it. It's about how you have the discussion in a way that shows tolerance. One thing that I think is a legitimate critique of many people who have these discussions, I think you have to have the space to be wrong. When people talk about racial injustice, oftentimes they don't feel there's safety and an opportunity to have a bad idea that needs to be fixed, right? So it's a very emotionally difficult discussion to have. But I do think we have to create environments where people have the space to learn and make mistakes and still be part of a community and not just descend into attacking each other. So that's probably the best way to try to bring that into K through 12. But I do think that the K through 12 discussion around critical race theory issues is really about understanding history and whether people are willing to have a full discussion about all of our very difficult challenges as a society, or whether people feel like we don't have the emotional fortitude, like we're all too brittle emotionally to tackle the difficult issues without just falling apart. So it's really about being comfortable having difficult discussions. Thank you for that question.
Hi, Jordan. I'm Wyatt Hammond from Temple University.
Okay.
I understand my theory of change to be that I want to fight for the legal fairness in regards to minorities, especially my community, the African American community. So my question to you, in your opinion, what would be the most effective way for you to accomplish that?
Interesting. Could you repeat that theory of change? You said to fight for
Equal legal fairness in regards to minorities, especially African American.
right, equal legal fairness. Yes, great question. So the first part of that is understanding what it means to be fair. That really, you're going to spend your whole career in law school trying to understand what that means, right? So does that mean equal access? Does that mean equal outcomes? Do we need to have equality in outcome, or is there something else? Does that mean that, does equality and fairness mean that on a procedural level, we use the term notice and hearing, right? So on a procedural level, under the Constitution, everybody should be able to get their day in court if they're accused of a crime. Everybody should have an opportunity to have a lawyer, right? Now, is it fair if I have a public defender that can only spend 5 minutes with me, and the other defendant can afford a high-priced lawyer who will set aside everything else in their life for 6 months to just focus on their case? I don't think that's fair, right? But right now, our system says that both of those instances are constitutional. So is there a way that you can try to bridge that gap? Can you provide more opportunities for people to get better representation even if they can't afford it financially? That's one example of a chance to try to create more fairness. The way to go about it, though, is to think about a situation that you think is unfair. What situation out there is unfair to me? And how could I use my tools to try to create more fairness in that situation? So it's up to you to decide if it's going to be in a criminal defense context, or if it's going to be something that will be in another context, intellectual property, small businesses, healthcare, education. Because we're all limited in our resources, we can only do so much, but if we can help to make the world a little bit more fair, then I think that's what it means to be a lawyer as a public citizen. Good question, thank you.
Hi, good afternoon. My name is Anthony. I'm from FIU. I wanted to thank you for your time, but I also had a question because I was taught critical race theory and assimilation in the spring for a Latino politics course I took, where I actually had to write a thesis paper where I determined whether I felt as though I fell under an assimilation bracket or a critical race theory bracket with my experience as a first-generation Cuban American here in America. So I guess my question to you is, what can you say for those who feel as though they actually have assimilated rather than been had more of a relatable experience to critical race theory in terms of their upbringing and experience in this country?
Interesting. Thank you for that question. So one concept of critical race theory is this idea that historically, if you think back to the 1920s, we had a big uptick in the number of immigrants that came into American society. Think about Ellis Island, and think about all these things that took from the 1880s to the 1920s. And during that time, there was a concept called the melting pot that was created to articulate what we aspired for these immigrants. We wanted them to be part of American culture and sort of mix in, and ultimately this idea that every different culture would then be assimilated into American society, and you would become American and lose the previous identity you had and fully encompass this new American identity, right? That was the melting pot idea. Over the course of the 20th century, surprise, surprise, come to find out, many of the people who immigrated to American society did not want to completely forget about their heritage. And although they did want to participate in our culture and in our democratic institutions, they didn't want to completely lose their previous identity, per se. So we've been trying to come up with a new way to think about inclusion into the American democratic project without having to demand that people eliminate their previous culture. And one situation in which this came up in Arizona, where we had a previous event, was this question around English-only laws in Arizona, and later on, a question around Mexican American Studies programs, where there was an idea that we needed to force people to completely assimilate, even to the point of no longer using their language from their previous country, right? So that's the debate. The alternative to full assimilation, there are multiple alternatives. It does not necessarily mean that there's this idea of creating separate enclaves, right? But this idea of embracing a concept called pluralism. So the pluralistic idea is that people of different cultural heritages can live alongside each other and still make up a robust community where there's communication between each other, where there's mutual respect, and more so than tolerance. I embrace the idea of respect, because it's sort of like tolerating people is sort of like the least you can do, I think, but more so thinking about embracing the benefits that people bring from their unique cultures and allowing that to be a part of our community and providing the same level of care and love and warmth to everybody, regardless of their ethnic background or religious background. So I myself believe in the pluralism concept more so than the melting pot concept, because I don't think people should have to completely eliminate all of the things that they should be proud of from their culture when they immigrate to the United States. I think that we should try to live alongside each other in a pluralistic community. And I think the critical race theory, again, the critical race theory is a way of entering discourse, right? So both of these ideas will be put alongside each other, and you can think of the pros and cons of each idea before making your decision like a judge would do. Here's the plaintiff, here's the defendant, listen to both of their strongest arguments and make your conclusion. So people have the right to come in different positions on these issues. But I think being courageous enough to have that discussion is a plus in the first place. Because you cannot get to a solution if you're not courageous enough to even ask the right questions. So thank you for that question.
We have time for one more question, Liz.
Oh, we want more to join this.
Hello, I'm also from Florida International University. My name is Manuel. I wanted to ask more about bail reform,
Yes.
because I believe it's a very important issue. And I've seen how different states have tried to handle it, and I wanted to see what options we have, because there's been some cases where instituting the wrong type of bail reform that makes the community less safe. And I want to see what we can do to get justice for people under bail reform that also keeps our community safe.
Thank you. Yeah, these are, one more time, I'm gonna say this, as lawyers, we're law and politics are intimately connected. So as a lawyer, you're gonna be in the middle of all these hot button issues. You can't avoid it. Don't try to avoid it. I know there's been a political discourse around this idea of catch and release and bail reform as this concept where we're ultimately less safe if we make it so that there's no cash bail, no money bail, because all these people will be in and out after they're arrested, back on the streets committing crimes. The other side of the debate, which is the side I'm on, is the understanding that if you have these high money bail regimes, you create ultimately what we call debtors' prisons. And in American society, at our founding, there was something where people who owe some money to the bill collector. How many of you guys have bills that you have to pay? Almost everybody. So if you're late on that, back a couple hundred years ago, they had debtors' prisons. If that 60-day late notice came in your mail and you didn't respond to it, if that phone call came in and you didn't respond to it, of course it wasn't a phone call back then, you might find yourself in prison. So the idea that we want to find a middle ground where we're not trying to create a debtors' prison society where people for financial reasons are in jail more so than for reasons of justice or community safety versus catch and release. Finding a solution in the middle of that is a very complicated process. One thing that people have started to do is to try to have bail decisions made not based on financial reasons, but purely based on safety reasons. So those are questions that could then be argued by judges as to the effect of the community's interest in allowing someone to have bail more so than the economic standard for bail, right? So eliminate the economic element of it and have the decision based purely on community safety. Now that is a process that then puts more of an onus on judges and attorneys at this pre-trial stage to make effective arguments. Because again, remember, this is pre-trial. So remember, one more time for folks, you'll learn this in your first year, right? You're arrested, you go to jail, and then you face a bail or bond decision before your actual trial. And most of you guys know trials are a vanishing phenomenon in American society. Over 90% of criminal matters are resolved through plea bargains. And over 90% of civil matters are resolved through settlement. So over 90% of all legal matters don't ever go to trial, even though they could. So the reality of the situation, to answer your question, is that pre-trial is really about pre-plea bargaining. And so there's always a negotiation happening. And it's really, the role of your attorney is going to be paramount in that dynamic anyway. So I do favor the process of having these decisions made without money being involved, because oftentimes, this is a question that's going to be based on some sort of financial decision. I think that's unjust. I think that it has to be based on public safety alone. And if you don't have representation at that point in time, you're going to be at a very sharp disadvantage anyway, especially when it comes time for your plea bargain. So people are in a bad situation. One more thing I want to say about Florida. I had a case out there. The public defender system is so under-resourced in the state of Florida in particular. So we talk about a crisis, lawyering in a time of crisis. That's certainly a crisis in terms of the public defender system in Florida. And I think that's an example of the type of cause that I think is a noble one that most people could agree on. Trying to find more resources for public defenders. So even during these bail and bond processes, people have a voice. I'm going a little fast, I know we're facing time, but there are a lot of people who are in the bond and bail pretrial portion who are unfortunately not getting assigned public defenders in time to really have that defender be able to help them through that process. So if you have a process that's not based on financial issues, it's based on judicial conclusions, they are at a sharp disadvantage because they don't have enough access to their public defenders in Florida. So to create a new system that does not rely as much on financial considerations, you're gonna have to have a more robust public defender system to help people get good representation at that pretrial stage. So unfortunately, it's going to cost something. It's going to cost something in order to make that system work correctly, but I think it's the right thing to do. A really, really good question, complicated question. Anyone else? Are we out of time? Or?
Yeah, we are just at the end of our time now, but it feels like it flew by. Thank you so much for that incredible presentation.